I'm very much heartened to be standing at the front of a standing room only seminar at the National Lawyers Guild Convention on challenging the surveillance state. It's a room that is clearly filled beyond capacity with National Lawyers Guild attorneys, legal workers, law students. And when I look out at the crowd, I think of those HUAC documents and the other government documents identifying the National Lawyers Guild as a subversive organization. And I look out at so many familiar faces, so many subversive elements, all in this room. And I just want to say I'm honored to be here in such good company. Because we know it's the surveillance state that is really what is subversive. It's a surveillance state that's subversive of our constitutional rights, of our civil rights, of our rights to religious freedom, to freedom of association, to the basic freedom to be free of government misconduct. So, and I know that the Guild-associated attorneys, unlike perhaps others who may be interested in refining the surveillance state, the National Lawyers Guild associated attorneys and legal workers and law students are interested in bringing it down. And if we can't bring it down today, we're going to bring it down incrementally by obstructing it case by case, client by client, opportunity by opportunity. And that's one of the things that we have here that is different than, say, any other just ordinary gathering of persons. The Guild recognizes and historically has exercised the power to impede unlawful government conduct. We have the use of litigation. We have the tools that come with that. So in all of our cases that we bring, it's essential that we focus not just on what we may have been focusing on, the immediate effects of a false arrest, but we recognize that because the surveillance state is omnipresent, surveillance is actually an issue that is omnipresent in our cases. Every arrest of a political activist or a religiously based arrest has got a component of surveillance. And the concrete manifestation of that, the end product of that, is the depositing of data into databases. And that's what they don't want us to know about. That's what they try and keep secret, is what are those data collections. But we have an avenue in. We have an avenue in through our litigation. We have an avenue in through our claims for equitable relief. Every arrest is going to lead to deposits of data in databases now. Not just the NCIC, but in the super secret ones that they don't want to talk about. And every arrest, every false arrest, has expungement as a proper remedy. So that means that for us as attorneys, every time we have a case, we have to think, let's follow the trail of the data. Demand and discovery. Where does the data go? Where is it deposited? What are the record-keeping systems? What are the fields of data? How is it disseminated? How is it distributed? Because we have a right to know, because we need to expunge the unlawful entry of data that comes from, for example, false arrests. When we're doing our claims, we know that, for example, the government always says you can't challenge surveillance, that Laird is this huge obstruction under the law. But in fact, it's an extremely narrow case, and the cases subsequent to it characterize it as that. And it's very clear that surveillance, when accompanied by unlawful disruption or unlawful conduct, can be challenged by claims for injunctive relief to make it stop. So that, for example, in our case coming out of the January 2001 inauguration, where it was discovered that the undercover agents were shockingly engaging in acts of provocation, secreting themselves among protesters in organizing meetings and coming up with these ridiculous demands that others plant bombs or plant fake bombs and call in bomb threats, things that was extremely disruptive, in fact, to the organizing activities, because everyone that was engaged in political activism was not engaged in that, and that really brought things to a stop. We were able to demand and get a court order that the MPD in that case disclosed to us all of the identities of their undercover agents. so that we could then show them to key activists, and they could associate who said what to whom on what days to build our case for unlawful disruption. And the government said, but if you do that, that's going to destroy the effectiveness of our undercover activities. Well, so this is what we need to be doing, and there's a lot of materials that have been distributed. We're happy, certainly, to share everything that we have done, and we certainly ourselves benefit from the free exchange with other attorneys working across the country, and I'm very happy to be here and appreciate everyone's time here.